Thank you so much. So again, my name is Heidi Klippel, and thank you all for taking the time to be here for today's presentation. Today, we're going to talk about being a fiduciary and what that job entails. So when a person creates an estate plan, they nominate a person to be their financial advocate. And when you agree to be a financial advocate for a third party, those duties attach what's called a fiduciary duty. And in the state of California, when you agree to be a fiduciary for a third party, that is one of the highest levels of responsibility imposed by law. So it is really important whenever you do agree to be a fiduciary for a third party that you understand what those duties entail. So typically when a person agrees to be a fiduciary, they're going to be acting in a capacity of either being what's called a durable power of attorney. And that's a legal document that's written that basically gives you a legal authority to act under a document when a person has assets titled in their individual name. So for example, if I had a bank account at Bank of America that was titled in my individual name, and if I had what's called a durable power of attorney, and if I named my husband as my durable power of attorney, I would be giving him my legal permission to step into my shoes, and he could deal with that bank account on my behalf. So when you're a fiduciary, your job legally is like a manager of a financial asset. And sometimes people understandably mistake being a manager with being a co-owner. And that is a big nuance in the law. When you're a co-manager, you're just managing assets on behalf of another person, but you do not co-own assets on behalf of another person. And when we create estate plans here at our office, part of what we ask our clients to do is to take their estate planning documents to their financial institutions and to title their assets into their trust. And basically, a trust is similar to a durable power of attorney in that you nominate a person called a successor trustee, and you're giving your successor trustee your legal permission to deal with the assets that you titled in the name of your trust should you lose capacity, and then to administer those assets at the time of your death. But what I find what happens with many of my clients is when they go into their financial institutions, a lot of bankers especially will tell clients that it's a lot easier, which basically translates into it's less paperwork for them to name their loved one as a co-owner of the asset than to have the asset go into the name of the trust. And legally, that's a big difference because if I'm a single person, hypothetically, and if I name my adult child as a co-owner of my asset, and if my daughter later gets a divorce, then her soon-to-be ex-spouse could try to claim that my asset that my daughter now co-owns with me is part of their divorce. Whereas had I put my daughter on as a co-trustee or as a durable power of attorney, which means co-manager of that asset, then her soon-to-be ex-spouse would have no legal argument trying to claim that they own part of that asset because my adult child would be acting as a co-manager of that asset and would not be deemed a co-owner of those assets. So it's really important when you create an estate plan or when you're coming on acting as a fiduciary on behalf of another person to understand what that means, because legally you're appointing somebody to come on to be your financial advocate for you, which means co-manager. So when you create a trust, you want to think of your trust metaphorically like a bucket. And what you do in the state of California is you put your real property into that bucket and you put your taxable assets into the bucket, because that's how those assets avoid a process called probate. And people can either have their trust written where they can bring on a person who's called a co-trustee while they're alive and they have capacity, because understandably, some of my clients get to an age where maybe mentally they're not feeling as sharp as they did in previous years. So they might bring on, whether it's an adult child or a best friend or a brother or sister or a niece or nephew, but a trusted person to come on as a co-trustee with them. And that co-trustee is a fiduciary. And basically what that co-trustee is doing is they have the same legal power and authority to co-manage those assets that are titled in the trust as the person who legally owns the trust. The nuance, though, under the law is when assets are titled in the trust, the owner has the ability to basically do whatever they want with those assets. They can make good and bad financial decisions with those assets. But the nuance with a fiduciary is they must act as a reasonably prudent person would in similarly situated circumstances. I don't know why that was so hard for me to say, which basically what that means is if I brought on my adult daughter to co-manage assets with me as a co-trustee because I'm a widow and I'm 97 years old and I'm not feeling as sharp as I used to, and I want a second set of eyes as far as the payment and management of my assets every month, I can do with my monies whatever I want. I can be super aggressive with my investments, or I can be super conservative with my investments because I legally own my investments. There's no legal standard imposed on me as the owner of those assets as to how I manage and use my assets. But when I bring my adult child on as a co-trustee, because she is acting as a fiduciary because she doesn't own my assets, I do, there is a different legal standard imposed on her as to how she manages my asset. And under California state law, that legal duty is for her to act as a reasonably prudent person would in similarly situated circumstances. There, I said that a lot better. And basically what that means in plain English is she can't be too high risk, she can't be too low risk. She basically has to be right in the middle when it comes to how she manages and invests my assets. But more importantly, from a common sense point of view, what she can't do is she can't take monies out of my bank account to pay her personal bills. She's legally expected to use my monies to pay my bills because that's what a person would be doing as a co-manager of my assets. And under California state law, if she made any kind of a mistake when it comes to my assets, even an innocent mistake, I could take her into court and a judge would make her pay out of pocket to reimburse me if a judge found that she was derelict in her duties as a fiduciary co-managing my assets, which obviously, hopefully none of that would ever happen, but that's how the laws play in the state of California. So when you have a person acting as a fiduciary, it often will happen where a person is alive and they have capacity. Sometimes people are at a stage of life where, as I mentioned, they want a second set of eyes to just help them co-manage their assets. Sometimes people are leaving the country for a period of time and they want somebody who's in the country managing their assets. And then oftentimes what happens is these documents are written that when a person legally does lose their capacity, that's when the person who owns these assets legally loses their ability to manage and control their own assets. And that's for their own protection, to protect them. And that's when the documents give the next person named in the document permission to come in and be the legal manager of those assets. So in a trust, the successor trustee as a fiduciary has legal authority to manage the assets that are titled in the name of the trust if they choose to accept that nomination. And in a durable power of attorney, if it's written to be triggered when and if the person who created the document loses capacity, then the person listed does have the ability to accept or to decline the nomination to act as far as managing assets that are titled in the individual's name. Because that's the nuance between those two documents. A trust and a durable power of attorney are two estate planning documents that give legal powers over managing a person's financial affairs. And the nuance is you'll use the trust when an asset is titled in the name of the trust, because that's how you get permission to manage those assets. And you use a durable power of attorney when you're dealing with an asset titled in an individual person's name, because that's the document that gives you legal permission to manage those assets. So if you are named as a fiduciary, the way that the easiest way to navigate that, because in the beginning, it's often confusing to know which document to use, you always want to look at how an asset is titled. So if hypothetically you were getting ready to sell a vehicle because a person can no longer drive, oftentimes a car is titled in an individual's name. So that would be the durable power of attorney for financial affairs that would give you legal permission to sign all the paperwork to sell the car. But if a house was needing to be sold, because a house is often titled in a trust so that it would avoid probate, it's the trust that would give you legal permission to step into the owner's shoes and sign all the documentation to sell that asset. So again, when you're acting as a fiduciary, you have two different types of roles. One is while a person's alive, whether they have capacity or whether they don't have capacity, your job is to be a financial manager, which is basically a bill payer. Your job is to step into that person's shoes and to help co-manage their assets for their benefit. The tricky thing though is I had a situation one time where a client called me and she was acting as her sister's durable power of attorney, and it was Christmas time, and she said, I don't know what to do because normally my sister would buy her children Christmas gifts, but my sister is in assisted living. She doesn't have a lot of assets, and I'm afraid if I buy Christmas gifts for her children that we're going to run out of money sooner than later. And in my heart of hearts, I just don't really feel like that's a good use of money. And I said, well, I'm so glad that you called and asked me that question, because honestly, your job now that your sister has lost capacity is to use her monies for her needs and for her living expenses, medical expenses, and for her support. I said, with all due respect, her children are going to understand if this year is the first year of many that they're not going to receive gifts from their mom. I said, my advice would be to get a lovely Christmas card and write a note in it of maybe one of your favorite memories of them with their mother, and have that become the new tradition. Because there's always a way of making a good memory out of kind of an unfortunate situation. And it doesn't have to be about throwing money at things. And I was so glad that she called, because she actually would have been breaching her fiduciary duty to her sister if her sister was running out of money and maybe wouldn't have had enough money to pay for her sister's care, but she was using her sister's money for things other than her sister's care, even if it came to buying presents for her sister's adult children. If her sister's children were minors, then the situation would be just a little different. You could probably justify buying minor children some inexpensive gifts, maybe from the Dollar Tree, but buying adult children Christmas gifts is not something that you could justify in those circumstances. So when you are nominated to be a fiduciary for a person, primarily what you're being asked to do is to be their bill payer while they're alive. And if they have capacity, I just want you to know, because I had this happen with another client of mine. Her aunt asked her to become her co-trustee and durable power of attorney, and her aunt was fully lucid. And her aunt was the type of person who just really liked to spend money. She was single and didn't have any children, which is great. And she had a lot of money saved at her end of life, and she loved to do sweepstakes. And in her heart of hearts, her aunt was convinced that the more money she spent on sweepstakes, the more likely she was going to win this mega million, multi-million dollar prize. So my client called me and basically said, look, I need to pull her power of attorney and get her conserved by the courts because she's making really bad financial decisions. And so we talked about the situation, and basically she told me, I don't approve of how she's spending her money. And I said, but is she incapacitated? And she says, well, what does that mean? And I said, well, to be incapacitated, a person has to really not know who they are or where they are. They have to be incapable of making legally binding decisions. And she says, no, she's perfectly capacitated. She knows who she is, where she is. She just voted for the president. She's totally fine. And I said, well, then just know that as her fiduciary, your job is really to help pay her bills and make sure that her checkbook is being balanced. But your job isn't to have an opinion as to how she chooses to spend her money while she has capacity. I said, I'm with you. I'm not a big proponent of sweepstakes. If it were me, I wouldn't spend my money that way. I said, but because she does have capacity and because she does have plenty of money, you really just need to let her spend her money the way that she chooses. And legally, you can't take her spending powers away from her just because you don't approve of how she's spending money. And that was really a difficult conversation to have. My client wasn't very happy with me because she didn't like my answer, but that's just how the law goes. We're not allowed to have like subjective opinions about how another person spends their money when they have capacity. But when a person lacks capacity and when you're their financial advocate, the law is very clear that you have to be in the middle. You can't be too high risk. You can't be too low risk. You have to be right in the middle. And for those of us who say, well, I'm not a financial advisor, I'm not a CFP, I don't really know what that means, then the best thing for you to do is to go meet with a financial person and get the advice to find out what that means, because that is what the law would want you to do. Or you can look at how investments are and which ones are on the aggressive end and which ones are on the low end, and then pick the ones that are in the middle. Ideally, there are investments that have FDIC insurance. It's always nice to have those investments that have the insurance protection. But at the end of the day, there's always ways to get the advice. And whenever you're in a fiduciary situation, if you ever have a doubt as to what you should be doing, you should always go and get the advice, because under the law, you would be expected to get it. And the person who has asked you to do that job would be expected to pay for the advice that you're receiving. The other thing that's important to point out is a lot of times people will ask me when they assume this role whether or not they're personally liable for the debts of the person that they're advocating for. And the answer to that is you're not personally liable for the debts of another unless you sign a contract where you personally agree to be a personal guarantor for that person. And oftentimes the way that that scenario occurs is when a person is going into assisted living. If you're asked to sign a contract, I mean, to be honest, if you're ever asked to sign a contract of any kind, even if it's not for assisted living, there's oftentimes language buried within the language of those contracts that has language of personal guarantor that legally you're not required to sign. But the purpose of that language is to say that if the person who's moving into the assisted living, should they run out of money, by you as the trustee or durable power of attorney who's managing their money, signing that contract, you're personally guaranteeing that if they do run out of money, that you're going to pay from your own pocket whatever money is short. So as a person's trustee or durable power of attorney, or even as an executor after they pass away, if you're ever presented with any kind of a contract or written document or any kind of a financial statement, you always want to read through that document from beginning to end in its entirety. And if you have any questions, hire somebody that can read through it for you to make sure that you are not voluntarily signing a document where you are personally guaranteeing a debt for a third party. Because once you voluntarily personally guarantee a debt, you are personally obligated to pay any debts of that person, where under state law, you would normally not be required to pay those debts. So then what happens is when a person passes away, their estate needs to be administered. So when you're a fiduciary, your job changes after the death of that person. And I should mention that at any time in this process, whether it's while a person's alive or whether it's when the person becomes incapacitated or whether it's after the person passes away, all of these documents that nominate you have powers of resignation. So these documents do have the flexibility of allowing you to resign at any time for any reason, which sometimes people do need the flexibility of resigning. So just like you can agree and accept to become a fiduciary, you can always at any time say, I need to step down because I've done what I can, or my life has changed, my circumstances and situation has changed. I need to step down and give everybody notice that now the next person needs to decide if they're going to take this over. The other thing is when a person passes away, if they died while they had capacity, when they die, their trust becomes irrevocable. If during their lifetime they lost capacity, then at the time of their incapacitation, that is when their trust became irrevocable. And as a fiduciary, your job when they lose their capacity, you are under a duty to provide their beneficiaries a document called an accounting. And the purpose of the accounting is to account to the beneficiaries of the estate as to the management of the monies. And that is really to provide transparency so that you're doing right by the incapacitated person, so that the beneficiaries of the estate can see what's happening with the finances. They can ask questions about the finances. And that is how the state of California makes sure that there's really a check and balance, that when a person loses capacity, and they don't have the wherewithal to look at the finances and make sure everything's going properly, then the beneficiaries of their estate are entitled to look that over on their behalf and ask those questions for them. But when a person has capacity, all of that is legally private and confidential, and a trustee doesn't have to provide any of that information while the person is living. But when the owner of these assets dies, that is when their trust becomes irrevocable. And that is when the fiduciary's job changes. And that is when a trust has to be administered. So when you're a fiduciary, it's important to understand the nuance that while a person's alive, your job as a fiduciary is really the job of being the bill paying manager. And then when a person dies, your job is to administer. So when a person passes away, one of the things I would encourage a fiduciary to do is to get the advice of an attorney, because all states have different laws. So you want to make sure that you understand the laws of the state that you're in. In the state of California, we have a very specific legal process that must occur. And even if you don't know that process, once you agree to be a trustee, which is a fiduciary duty, the state of California, once you agree to be a trustee, imputes on you all the same knowledge that I have after practicing law for 23 years. So the nice thing about these legal documents is they all have language written in them that anytime you go and seek professional advice, whether it's a CPA or an attorney or any professional, the estate will pay for that advice. So you're not expected to pay out of pocket. And my best advice is to, especially in the beginning, go get that advice so that you know from the very beginning exactly what you're expected to do. Because sadly, sometimes people call us 6 months after a person's passed away and they've already done a whole bunch of things with assets and things that they never should have done. And now the estate is a total mess. And some of the time we won't even get involved because there's just too much of a mess to clean up and liability. And it's just better to not even go there. But basically, the way trust administration works in the state of California is the first thing that the fiduciary trustee does is they send all of the beneficiaries that are named in the trust a legal document called a notice to beneficiaries. And the purpose of the notice is to notify the beneficiaries that the owner of the trust has died, the trust is now irrevocable, that they're a named beneficiary, and that the person who's sending the legal notice has agreed to be the trustee of the trust. The trustee has the option of sending the estate planning documents or not. Depending on the situation, it's usually my advice to send the documents because it's a good thing for the trustee, for the beneficiaries to be able to read these documents. It's rare that the advice is different, but there's always that rare situation. When you send the legal documents with the legal notice, the beneficiaries have 60 days from the receipt of the notice to contest the estate. So the importance of sending the legal notice is you're opening and closing the statute of limitations for beneficiaries to contest. The trustee is also under a fiduciary duty to notify the heirs at law of the decedent. And what that means is if I died and if I didn't have any children, and if I wasn't married, and if my parents have died, and let's say I had 3 siblings, heirs at law would be my closest living relatives under the law, which in this hypothetical would be my 3 living siblings. But let's say my trust gave everything to the San Diego Zoo. Under California law, my trustee is under a legal duty to send my beneficiaries, which is the San Diego Zoo, a copy, the notice under California law, and probably a copy of my trust and my will and any amendments thereto. But they would also have to send my heirs at law, which is my closest living blood relatives, this notice as well, which would be my 3 living siblings, because they're also entitled to notice because they might contest the estate because they're not a named beneficiary. So it's important to note that in some situations where people might disinherit people, whether it's a child or a spouse or a stepchild or best friend or whoever it might be, depending on what your legal or blood relationship is to a decedent, sometimes people are entitled to legal notice of your death. And people don't always realize that that's how the law works, but that is one of the many fiduciary responsibilities attached to a trustee. So once the notice is sent, the next job of the trustee is they have to basically figure out whether or not probate is required. And probate is going to be required in the state of California if there's any real property that's not titled in the trust. And then probate would also be required in the state of California if the decedent had any assets titled in their individual name that didn't have a beneficiary attached to it, that when you add all assets like that together, the total aggregate value exceeds $184,500. So what that means in plain English is if I died and if I had a bank account at Merrill Lynch with $60,000 in my name with no beneficiaries attached to it, and if I had a $3 million account at Bank of America in my name with no beneficiaries attached to it, and if I had a car in my name, obviously with no beneficiaries attached to it, because when you add those assets together, their total aggregate value exceeds $184,500, then those assets would trigger probate. So a trustee has to figure out whether or not any of these assets are subject through probate. And if so, then a petition has to be filed with the probate court to start that legal process. And then once the trustee has that figured out, the trustee sends to the beneficiaries a document called an accounting. And the purpose of an accounting is to account to the beneficiaries of the trust as to what assets are in the trust, what debts the trustee is aware of. But one important nuance to understand as a fiduciary is if you have a trust that has specific gifts that give a lump sum, let's say that a trust gives $15,000 to UCSD and gives the remainder to all the children equally. Because UCSD is getting a lump sum certain, they're not entitled to an accounting because they're getting a specific sum of money. But because the children are getting the remainder of the estate, which is a percentage, they're entitled to the accounting because they're entitled to see the asset and debt of the estate from start to finish. So the trustee sends to the beneficiaries receiving percentages of the estate the initial accounting, and then the trustee throughout the duration of the trust administration, part of their fiduciary duty is to basically treat the accounting like a check register and to always be updating it when assets come into the estate and when assets come out of the estate. And then the trustee is basically going to meet with the decedent CPA to make sure that all of the taxes and are current and filed, and then talk about whether a final state and federal income tax return is going to be needed for this year or the following. Because sometimes some people aren't filing state and federal income tax returns. Sometimes trustees find out that there's delinquent state and federal income tax returns that need to be caught up, paid, and filed. So that's also a trustee's duty, is to deal with the state and federal income taxes. And then the trustee, if they locate the original will of the decedent, they're under a duty to deposit that with the San Diego probate court or with the local probate court in the county where the decedent died. And the purpose of making that original will public is because the creditors will audit the business office in the probate court. And if the decedent owed a creditor money that maybe the executor wouldn't have reasonably located, that executor will now get in touch with the executor telling them that, hey, this person owed Macy's $500. Here's a copy of the bill, please pay it. So part of the trustee, who's also the executor's job, is to make that original will part of the public business office at the probate court, so that creditors can identify the executor, look up the decedent's name to see if they're owed any money from the decedent. And then when a person dies, their social security number dies with them. So the fiduciary is under a duty to apply for an EIN. You're also placed into a higher tax bracket after you die, and that's intentionally because the government actually wants your assets to be distributed to your beneficiaries sooner than later, which is why the EIN replaces your social security number. And that's also partly because assets in the trust becomes irrevocable, and irrevocable trusts are in the highest allowable tax bracket under federal law. So the trustee will go into the irs.gov website to obtain that EIN number. And that's going to be used when filing the final state and federal income taxes. And you can apply for that irs.gov or your CPA or estate planning attorney. And that's just online. If you're on the correct website, it's free. If you're on the wrong website, they're going to charge you. And then you're going to get to a point in this trust administration where you're going to read the terms of the trust, and you're going to ask the beneficiaries if anybody wants a particular asset that's in the trust, because oftentimes you might have 3 beneficiaries, but 1 house. And sometimes one of the beneficiaries might say, I want the house to be part of my share. So then the trustee is going to deal with who gets the house. And if you're lucky, there's going to be a lot of liquidity so that the house can go to the 1 beneficiary and money can go to the other 2. Somebody just posted about, I see that this is being recorded. May I impose on you to share the recording? I don't have a problem with sharing the recording. I just don't know how to do that. I don't think that's something I do. I don't have a problem with sharing the recording whatsoever. I just don't know how to do it. Anyhow, so then once the trustee talks to the beneficiaries and decide who wants what, then the trustee can deal with that. One tricky thing though is that Prop 19 was enacted, which chipped away at Prop 13. Under Prop 13, it used to be that if a person had 3 properties, as long as it was a parent-child gift, children could inherit all 3 properties and keep the property tax basis to all 3 properties because it was a gift from parent to child. But now under Prop 19, the only way that your kids will keep your property tax basis on your property is if it's your primary residence only. So if there's more than 1 real property being inherited, the only real property where the property taxes can be maintained is on the primary residence. So in my hypothetical, if there's 3 properties being inherited, 2 of them will be reassessed automatically because it's only the primary residence under Prop 19 that you can keep the property taxes. And your children will only keep the property taxes if they move into your primary residence and make it their own primary residence. So now, because of Prop 19, a lot of times real property is sold, and that was intentional. The realtors lobbied for Prop 19 because there's not a lot of inventory in California. So where people used to hold on to real property because of that favorable property tax treatment, real property now is often being sold after people pass away, whereas before it was being kept in the family for multi-generations. And whether people moved into it or whether they rented it, but that is something to consider. So that's a whole new conversation that's now being had. And so once you deal with who gets the house, whether we're keeping it, selling the house. Then the trustee prepares the other thing that the trustee has to do is they have to notify Medi-Cal. Even if a person was not on Medi-Cal, they legally have to notify Medi-Cal, which they can do online, which is super quick and easy, or they can mail in a form. And basically Medi-Cal is going to audit a person's social security number and let the trustee know whether or not Medi-Cal is owed any money or not. And then after all of that is said and done, the trustee is going to prepare a document called a final accounting. And basically the purpose of a final accounting is to account to the beneficiaries that were at the end of the trust administration process. Here's the financial history from start to finish of the trust administration. Here's all the assets that are in the estate. Here's any additional assets that have come into the estate. Here's all the debts that have been paid. And if there's a tax return that needs to be paid the next year, the trustee can hold back something called a reserve. And the purpose of a reserve is just to hold back an amount of money for the purpose of paying that final tax return and paying the CPA. And then the trustee would also note in that final accounting whether or not they're taking trustee compensation. It's not uncommon in a trust for the owners of the trust to authorize the trustee to get a little bit of extra money for their time and trouble in administering the trust. And in the state of California, reasonable compensation is what's deemed the norm in California. And reasonable compensation is 1% of the net value of assets that are titled in the trust at the time of the owner's death. So if a trustee is going to take compensation, they do have to note that as an expense in the final accounting. And then once the trustee sends all the beneficiaries the final accounting, the beneficiaries have up to 180 days to ask questions. The trustee has to send with the final accounting all the financial information to substantiate the information in the accounting, bank statements, receipts, things of that nature. And then assuming that nobody has any objections or questions, then the trustee can make all the distributions to the beneficiaries. And then once the trustee makes the final distribution out of the trust account, and once the trust is depleted of assets, that's when the trustee's job is officially done. And that's when the trustee's fiduciary duty officially ends. So being a fiduciary in the state of California is a very important job. It's a job that you want to not take lightly, because under our state laws, being a fiduciary is very important, and the state of California takes it very seriously. You can't just say you'll be a trustee and not know what you're doing, because even if you make an innocent mistake, if you were to be taken into court and say to a judge, well, I didn't know that was the law, that's never an acceptable answer to a judge, because a judge would expect you to take the monies of the trust to go pay somebody to explain to you what that job entails. And if you do go to somebody and get the explanation as to what the job entails, and if you decide this really isn't for me, then the best thing for you to do is to not accept the job as a trustee. Or if you're acting as a trustee, and if there's, a fork in the road where you decide that it's just not working for you any longer to be a trustee, then it's always a good idea to give notice and to resign. I had a situation where a woman was named to be a trustee, but she was also a realtor by trade. And she had mentioned to me that she was super excited that she could double dip, because she wanted to get the trustee compensation and she also wanted to sell the house. And I said to her, you can't do both. It's a conflict of interest. So why don't you pick which hat you want to wear? Because you either need to be the realtor or you need to be the trustee. But in this situation, you can't be both. And she didn't like that very much. But that is still, unfortunately, a tenuous situation, and it hasn't gone away, because unfortunately, some people can't get out of their way and they don't know when to pick a lane. But when it comes to the law is very clear that you need to pick a lane and you need to stay in it. And communication is key. So I've had other situations where a trustee has said, well, I'll talk to this beneficiary, but I'm not going to talk to this one because we've never gotten along. And then I have to explain to a trustee that you are a fiduciary. Your job is to treat everybody equally and impartially. You can't let family business get in the way or cloud your judgment. You either have to talk to everybody and be a grown-up, or you need to not be a trustee and not let this dynamic affect your job as a trustee. And then sadly and understandably, I've had other people say, if I've taken 6 months to grieve and now I'm ready to be a trustee and do my job. And then I've had to say, you're really lucky your family loves you, because under the law, with all due respect, I understand grieving, but when you agreed to be a trustee, you agreed to do a job that under the law, you really should have started 6 months ago. I mean, the law doesn't care that you're grieving, because a private fiduciary or a corporate trustee 6 months ago would have started and they probably would have had this whole thing finished by now. You're not really allowed to say I'm grieving under the law when you agree to be a trustee. And if grieving is something you think that you need time out to do, which is certainly understandable, then the best thing to do is to decline the nomination or to ask somebody to come on and help you, because you can always ask the next person listed as a successor trustee to come on and be a co-trustee, and you can share the job between you, and then it's not all on your shoulders. So the good thing though is you always want to ask the questions, do the research, and see what your options are. Because I mean, as long as you're a good communicator, you're good with managing money, you're good at talking with people and treating people fairly, being a trustee, being a durable power of attorney, helping to administer an estate, it all works very well as long as you have the right people in charge. Every once in a while, things can go off the track, but sometimes it's unavoidable, because sometimes there are some dynamics that have been in existence that are just what they are. And sometimes that's when it is better to have a non-family member come in who's not related to do the job. And sometimes it's good to know when it's best to not have people listed and to just have the private fiduciary, the corporate trustee. Because I've had that situation happen too, where people do have the family on the documents, and then we have the meeting and we have the conversation and they tell me the dynamic, and it's decided, you know what, let's just go ahead and have a neutral third party come in. That way everybody's on the same page, everybody will trust, nobody's going to second guess or question. Because really, at the end of the day, you need somebody at the helm of the ship that everybody trusts, that everybody knows is going to treat everybody impartially and fairly, because that's really, at the end of the day, what the trustee's job is. So that is everything I wanted to say about being a fiduciary. If you have any other questions, feel free to post them on the chat. Hopefully that the handout talks more about the documents, because I thought it was important to understand how the documents work. I knew I would talk more about the job and the duties and the responsibilities. I don't really see any other questions. So I guess that's it then. So thank you everybody for your time. I hope you found this of interest and learned something. Enjoy your what about professional private people? So there are people called private fiduciaries. They're kind of like a corporate trustee, except that they're individuals. You really want to do your due diligence there and interview them and ask them, how do they charge? What's their approach? What's their process? Are they licensed? Are they bonded? Are they part of a company? Because I had a client one time who was terminally ill. She was single. She had no children. She had no extended family to speak of. She picked a private fiduciary as her first choice trustee, durable power of attorney, healthcare agent. And then I asked her, I said, who would be your second choice trustee if your first choice wasn't able or willing to act? And she said, well, I don't really need anybody. And I said, but what if you and this trustee were sadly both in the car when a drunk driver hit you, when you were both side by side in the hospital? If she was incapacitated, who would be your second choice to step in and be your advocate? And she says, but she told me I wouldn't need anybody else, that once she picked me, that she was all I needed. And I said, well, I understand that you like her and you trust her, and that's wonderful. I said, but in my hypothetical, if you were 95 years old and she was driving you to the bank, and if there was a car accident and you were both side by side in the hospital, who would be your second choice? And she says, I don't think I need one. And I said, no, but you do. You need to have a second choice or a third choice. So private fiduciaries are good options. You just want to make sure that you're interviewing them. And my best advice would be write out questions and interview at least 3 to 4 people, ask them the same questions, and then just see who you get the best feel for. Because obviously it's just kind of like a job interview, right? You're going to maybe click more with one and not so much with another. But you want to ask them, what's your approach? What's your process? How much do you charge? What information do you need from me? How are you going to know when I need your help? Who's going to contact you? Do you need my financial information? What about when my financial information changes? How are you going to know? So you need to have all that conversation with whoever you're interviewing. And then once you make the decision and hire them, there's a lot of information they should be asking you to give them. And then it says, how long does a child have to put the house in their name to stay within the same tax bracket for the house? So I believe, gosh, I think you have a year before the county recorder reassesses the house for property taxes, but they send you the preliminary change of ownership paperwork. And I think you do get a grace period if it's late. But that's all on the county recorder's website. And it says, is there a professional certification for those people? So yeah, the private fiduciaries, when they first started, there was no certification. It was so loosey-goosey. There was no licensing, really. It was very informal. But now the private fiduciaries have to undergo formal training. They have to get a formal license. I believe they have to have a bond under state law now. So luckily, it's really evolved in the state of California for private fiduciaries. What used to be pretty loosey-goosey 15 years ago, like anybody could say they were a private fiduciary. Now there's specific school requirements, credentialing requirements, licensing requirements, bonding requirements. Whereas 15 years ago, none of that existed, which was really, so 15 years ago, I wasn't such a fan of private fiduciaries. And it wasn't so much because of the private fiduciaries. It was mainly because there wasn't so much required by the state of California for them to become a private fiduciary, whereas now there's a lot. It was newer then, so there wasn't that much known, but now, luckily with time, with most things, there is requirements for private fiduciaries. A corporate trustee on the other side of the fence, one nice thing about a corporate trustee versus a private fiduciary is a corporate trustee is with a large institution. So they have deep pockets, they have a legal department. And to be honest, in my experience, I'm finding that by the time you add up all the time and hours that a private fiduciary charges, they pretty much are charging similar fees to the corporate trustee. So my advice would be, in interviewing the private fiduciary, you might as well interview a couple of corporate trustees as well, because dollar for dollar, they're probably going to come out to be about the same cost, even though it probably doesn't sound like it when you interview them. If you really take the amount of time, if you're paying an hourly fee, a private fiduciary is probably going to spend about the same amount of time that percentage that the corporate trustee is charging. And some private fiduciaries now are charging the same percentage that the corporate trustee is charging, but the corporate trustee is backed by the large corporation with the legal department. They've got the insurances, whereas the private fiduciary has none of that, but they're charging that percentage. They're charging the same amount of money that the corporate trustee is charging. So I would definitely, in interviewing the private fiduciary, also be interviewing that corporate trustee, because dollar for dollar, you might get more bang for your buck in going with a corporate trustee. But then in saying that, one potential downside of a corporate trustee is they don't like to exercise a lot of discretion, whereas private fiduciaries tend to be more willing to roll up their sleeves. So if you have a clause in your trust about drug testing, or about younger children, more private fiduciaries are probably going to be more willing to get involved in that kind of thing, whereas more corporate trustees, they're so afraid of being sued that they're more interested in just the black and white of trust administration. So you want to look at all of that. And then some corporate trustees now are really just wanting to be money managers, and they're not necessarily doing all the trustee things. So if you do go with the corporate trustee, you want to make sure that the corporate trustee is going to do everything that a trustee typically does: sell the house, file the tax returns, talk to the kids, do the accountings, not just manage the money part, because you want a trustee that's going to do all of it and not just a piece of it. So I think that covers all the questions. I don't see any more questions coming up. Thank you guys so much. Have a wonderful weekend. And thank you again for your time.